Hey, right, everyone, just bear with me a sec. I'm taking a chance of having a second monitor on tonight, and I don't know if it's going to mess up my display or not. So we'll see what happens because last time it went a bit weird. Yeah, welcome to this week's live stream, guys. Sorry about last week. I was out of town basically without any of the camera stuff. So, but there's not been many questions coming in on the channel, so hopefully no one's missed out too much. As always, this isn't legal advice. We're going to try and best to be helpful here. And as always, please don't share personal data. So if you're going to ask a question about your own situation, make it look like you're asking about someone else, or even better, a hypothetical person, because you get better answers that way anyway. Plus, you don't have to put your personal data onto the internet to get the response. Um, I don't know if anyone's got any. I've got a bit of gossip about training actually. We were just before we started, we were just talking about Karis going to a webinar thing on the Renters' Rights Act. So, but it doesn't seem like there's anything particularly kind of like snappy to say about it yet. It still seems like there's quite a lot of stuff up in the air. So we'll keep an eye on that. Hey, you all right, Michael? Um, in terms of training stuff, that so just for those who are interested, I've set out like the whole autumn's worth. In fact, into February now actually. So there's the standard introduction to homelessness law course, which is running. It's running tomorrow, but next times it's running the 31st of October and the 5th of December. And I've started running a whole day's training about priority needs. So first one went well. So I just need to tweak a couple of things here and there, but it was good. So I'm doing that again on the 24th. In fact, that one's booked out now. So I think the next one's the 21st of November. Basically, have a look at Eventbrite and sign and basically follow us on Eventbrite because we also do for like free stuff. So, for example, on the 14th of October, we're doing a little webinar on intentional homelessness. So basically it's an opportunity for first of all to kind of get a presentation about intentional homelessness and but also kind of ask questions as we go because I will generally be kind of answering questions just as soon as they come up. So yeah, check out those things. I don't know if there's anything else that we need to say. I think it's fair to say that Will and Karis are at absolute capacity, so are not able to take on new cases at the moment. Just because of just the way things are at the moment, I guess. Hey, you all right, Martin? Nice to have you here, mate. Um, so yeah, let's get into the questions. We've got one question from the week so far. So if people don't start asking questions in the live chat, it's going to be a short live stream. So here it is. A person is waiting for a reply to a formal second stage complaint, which the person should receive within 14 days. And bearing in mind, I think this was written like a week ago. I can't remember now. It might have been written a week ago. That person is also waiting for a Section 204 housing appeal, and the solicitor said there's a lot of merit to the case, so the person thinks he'll win the court case. When the person receives a reply to the second stage formal complaint, can the person ask the complaints team to leave the complaint open just in case the council decide to settle the matter early without going all the way to court? For example, what would happen with a formal complaint if a person decides to wait for a court case and then report it to the LGSCO, but the council might settle early without the court case? Can you explain the best way possible to sort this out properly, looking for maximum compensation due to distress, time, and trouble, and actual physical harm caused by supporting medical evidence by the GP? So um, basically, my answer to this is that the court case and the complaint do essentially completely separate things in this situation. The court case is just about whether if I remember correctly, this kind of comes from a sort of sequence of questions around, I think it's about suitability of accommodation. I might be wrong, but whatever it is, the court case will settle whether or not the accommodation is suitable. In fact, it won't even do that technically. Technically, the court case will establish whether or not the council followed the law when they made the decision. And if they didn't follow the law when they made the decision, the judge may quash the decision and tell the council to make it again. So, I mean, technically speaking, a judge can quash a decision and the council go and make the same decision again, just in a different way. So winning the case, so to speak, may, I don't think it would happen like this, but it's possible that it doesn't actually result in a good outcome. I mean, the reality is, I think in most cases, when the judge tells the council they messed up and the decision's quashed, they will probably make the opposite decision next time. So, but yeah, so that's going to settle that. There is, as far as I know, you're not going to get any money from the courts. That's not what it's there for. It's just to establish, did the council follow the law when they made the decision? Did they look at the right things? Did they disregard the right things? All that kind of stuff. So that's kind of separate from the complaint entirely. The complaint will be looking at, did the council is there? I mean, it's a bit of a crossover. It's a bit weird, really. But they'll be looking at, first of all, has this person been in this example in unsuitable accommodation at all? And if so, work out how much compensation to give them per month that they're in unsuitable accommodation. And again, the LGO aren't actually asking the question, is the accommodation suitable? Again, they're asking, is there evidence that the council actually considered the right things when they should have? Did they respond quickly? Did they, if there was reports about disrepairs or other issues or unsuitably, did they actually respond in a timely manner, or did they just leave it? Was there kind of delays in communication, that kind of stuff? And the fact that, if there's medical evidence to say that the unsuitable accommodation had a significant impact on the person's health, then that would add to the amount of compensation the LGSCO is likely to give. But yeah, but that's probably it. And again, we're not talking about a lot of money here, unless this person's been in unsuitable accommodation for years. So it's kind of depend on that, really. So yeah, so in terms of, and I guess the other thing I'd say about this is that once the council's given the stage 2 response, unless it's a weird council that's got a 3-stage complaints process, which most councils really don't have that. Most councils have a 2-stage complaints policy. So when the council's given that second stage response, that for them that's the end of it. So the next stage is then go to the LGSCO. And again, I don't, by the time the LGSCO have actually investigated, the court case will probably be finished anyway. So I would, without kind of knowing the details here, I would say, yeah, basically don't delay anything. There's no need to delay anything. If the council settle early, as in if the council accept that they've messed up beforehand and then offer the person suitable accommodation, then that doesn't change whether or not the council messed up in the first place. So you can still get compensation in that situation. So yeah, I'm hoping you're right, Mo. I'm hoping that makes sense. But effectively, yeah, I would see no reason at all to really wait. The only thing that might kind of happen is if the court case shows that the accommodation wasn't suitable, then that would probably be instructive for the LGSCO to reach the same conclusion. But I think even then it's actually slightly different question they're asking. And as I say, by the time you got into the LGSCO, it's 3 months before they even look at it. Last time I did anything with them, so by that stage, hopefully the complaint, the court date will be settled anyway. The Section 204 will be settled. So yeah, that's my answer to that. I don't know if you guys have got anything to add to that at all. Um, but yeah, as I say, I think just treat them as two separate processes, and there isn't much overlap really. Will?
I was just, well, it's more of a question really, and to see what you think is, because I know that there's a fear, I think, and maybe it's what's behind this question is people worry that if you go to the ombudsman and you've got a court case, they'll say, oh, we can't get involved because there's a court case. Um, but presumably, and I'm sorry for if you covered this just then, but if it depends what the complaint's about, doesn't it really? Because you could have a 204 appeal is quite a limited question, so there could be a refusal to provide temporary accommodation or something. Um, but I don't. I suppose if you won your 204 appeal, you couldn't really then make a complaint and say they made such a bad decision, I had to appeal it. But in a way, you should be able to because you can't get compensation from the court.
Yeah, no, you would be able to. As I say, it's I don't know if the LGSCO actually set out on a website what their remit is and isn't. Like they obviously give some idea, but I haven't seen anywhere like a really good explanation about how these two different strands of a complete of an issue are resolved and how they interact with each other. But yeah, no, I mean again, the LGS, the one thing you got to keep an eye on with the complaint is that you deal with it in a timely manner. So ideally, you want to get the complaint to the LGSO within 12 months of the problem happening or you becoming aware of the problem. But yeah, no, I think as far as I know, it's completely possible for a situation like this. As I say, I'm pretty sure it's about suitability of accommodation. So where essentially the council's decision that they made a suitable offer will be overturned or whatever the right word would be in court, and there will still be the possibility of complaining to the LGSO. That would be my understanding. I've not kind of dealt with that crossover before myself. Almost all my casework has been going to the LGSCO rather than going down the court process. So yeah, but yeah, I mean, I think this person, it might actually work out that this person comes back and tells us what the answer is, because I think in doing this way, you know, it's going to probably they're going to probably find out. I mean, I guess like as a similar kind of thing. Hey, you watch that? Nice to have you here, mate. Um, as a similar kind of idea, like with a data protection breach, um, again, this is the way I've done like kind of compensation for breaches before. So you initially complain to the organization, like the council, and then you go to the ICO, which is like the governing body or whatever of data protection stuff, and they'll then reach a decision and say, yeah, we don't think the council's followed the law, but we don't recommend compensation at all anyway, because it's slightly different from the LGSCO. But as I understand it, that decision from the ICO is going to help your data breach claim, because the ICO is kind of they know what they're talking about, obviously, and they are saying that the council has or the organization has breached the law. And then I think the court case is really then about how much compensation you would get rather than in a situation like that, that it's really obvious the breach has happened anyway. But yeah, it's kind of it's a funny one really, funny area in terms of that crossover. And as I say, I've not seen anywhere which kind of sets out clearly how these two things interact. Um, so okay, so just there's an update on the question here. So a person received the reply to the second stage complaint from the council. So yeah, I think because this question was put up like a week ago or so, this has actually moved on slightly. But basically, so a person receives a reply to second stage complaint from the council and they completely ignored the request for compensation. I'm assuming there's going to be more to this, but effectively, the fact they've not considered the compensation is just them being stupid, and I do mean that. I'll explain why I'm saying that in a minute. Because effectively, what you if I just copied them a bit the wrong bit. If the council, yeah, in a situation like this, if the council uphold the complaint but they don't recommend compensation, then all that's going to happen is you're going to go to the LGO and they're going to say, right, we've already settled that the council's messed up here. This is how much compensation you're going to get paid. So I'll give you an example of that. One of my first complaints I was involved in was a complaint with Shepway District Council down on the south coast, and it was a pretty serious breach. Really, they basically sent a domestic abuse survivor back to Bedford where she was fleeing from. Um, and they didn't, they gate kept her. They said they needed proof of pregnancy before they would help. Various other things. They messed up massively, really. And so I took it to stage one. They just kind of do the usual thing. Stage one, they just ignore everything. Stage two, they said, okay, yeah, we did mess up here. We're going to offer £150. And that was well under what the LGO would recommend according to their own guidance. So took it to the LGO. The LGO said, yep, pretty obviously this needs more than 150 quid. I think she got, I can't remember now, 600 quid or something. And what that meant, and the council and the Shepway had to kind of arrange training for its staff because they'd obviously done what they're doing. And so by not offering the right amount of compensation at the stage two, the council then had their dirty laundry aired by the LGO because the LGO published the decision. So they get some bad press for it potentially, and they only have to they have to go and pay the money anyway. So really, I'd say it's a pretty incompetent council officer who doesn't properly consider compensation at stage two because they're only, you're going to assume the person, the complainant is going to take it forward at that stage because they're obviously motivated to do it. They've gone through the stage one. So yeah, um, yeah, but as I say, it's not, it won't do any harm that, yeah, if the Section 204 is successful, it's not going to do the complaint any harm. But I'd be interested to know, did the council accept any failings in that second stage response? Because if they did, then it's going to be really straightforward for the LGO to investigate and recommend compensation. So yeah, um, right. So, how you up, Tiff? So I don't know. We're not well placed to answer questions about DWP stuff. I certainly don't know, and Shannon's not here tonight, so Shannon's probably the best, kind of best one to ask for that sort of stuff. Although I don't know if she know the answer to that. Not sure. But yeah, so next question. It's a multi-part, so let's just stick it back together. Um, hold on. There's quite a bit to this. I'm just trying to make sure I've not copied the same bit again because YouTube doesn't like copy and paste function, it seems. Okay, I think this is it. So, client has indefinite leave to remain. 20-year-old, formerly Kenyan. I'm going to nitpick there slightly. I'm going to guess they still are Kenyan. They're from Kenya. I know. Yeah, I know. I'm not. Yeah, ignore me. I'm just being pedantic. They might have now, but yeah, who knows? Applied to London Council for Homelessness Help. Placed in council owned hostel managed by St Mungo's. Stayed there about 8 months. Then became pregnant. St Mungo's policy is no children, so they issued notice to quit. Client went to council, told she couldn't stay. Or council told her she could stay. Council took no action. She had a baby and returned from hospital. St Mungo's then issued Section 21. Client asked for help, council for help again. Council said, wait in the flipping heck. I've advocated for her, but the council ignores all approaches. Baby's now 2 months old. Hospital, that's unbelievable. It's unbelievable on St Mungo's as well. Why is St Mungo's not doing something useful here? That's ridiculous. She's at breaking point. I suspect council hasn't even opened a homelessness case. They may be fobbing her off, but council owns hostel and St Mungo's manages. The roles are unclear. Need clarity on interplay between council as landlord and St Mungo's as manager. How to force proper homelessness duty. So okay, yeah. So yeah, a lot to say here, obviously. I guess my first question would be is, kind of going back to basics, how was the homeless application triggered? Was it done in an email? If this was me in this situation, I'd have done it by email, put out the relevant information. I probably would have attached a copy of the notice to quit and also the St Mungo's policy about no kids. And then the next day, if they didn't accept the application and provide interim accommodation, I would have then complained to the chief exec and just gone a bit nuclear, to be honest, because this is ridiculous. I would, by nuclear, I mean I would have sent it to the chief exec of the council. I would have copied in the councillor who oversees housing and children's services and anything else that might be relevant. It might be the client has they will have a constituency councillor or whatever, at least one. Copy them in, copying the chief exec of St Mungo's. I would literally just throw everything at it, basically. Children's service, just kind of everything. And I would be pretty confident that would work because there is no way that this is okay. I guess the kind of question might be complicated by this arrangement between St Mungo's and the council, but St Mungo's are basically saying this is not, this is just simply not suitable for a mum baby, which is very typical of support accommodation. That's not unusual. So yeah, so I think without unless you get a solicitor complaining forcefully is the way to go forward, I think, with this one. And as I say, just really kind of just throw the relevant kind of officers and managers or whatever into the same email, because I think this just looks, this is obviously bad. This is like, there's no way around that. And be prepared, I guess, for the council to then try and house them 100 miles away somewhere ridiculous as well. But yeah. So I mean, this is this okay. Just there's a bit more to it here, and this is very typical. So this is very kind of kind of common situation to be in, where effectively, the initial approach was not done like robustly. So it might be that the mum walks into the council and says, "Can you help me out?" And they say, "No, we can't. You need to go back and wait for the notice to quit." Nothing's in writing, all the rest of it. If there's nothing in writing and you then complain, the chances are the council say, "We never said that. That didn't happen," and so on. So in one sense, if you're new on the scene here, I would take it back to basics. Send the email. This is a homeless application. This is the situation. This is what the client says she's been told. Here's the policy from St Mungo saying she can't stay. Here's the notice to quit. All that sort of stuff, and just kind of just treat it from fresh, basically. And again, I would probably copy the homeless application in with the relevant councillors as well. And maybe also, if it was me, I'd send another email to the councillors separately and say, "Look, I think there's some problems here. Really would appreciate your help with this case." And then see where that goes, really. And then as I say, if they're not responded within 24 hours, follow up with a formal complaint and kind of keep going that way. So yeah, I think I'm hoping I'm not missed any of that question out, but that's my answer. I don't know if you guys have got anything more to say about that, really. I mean, it's crazy. It's just utterly crazy. And if it was me, I would be really wanting to pin St Mungo's for just that like apathy and lack of action. It seems, if this is correct, then I really want to know why they haven't done more for their own client, who they've probably paid quite a lot of money for to support. That's what support accommodation's for, right? Yeah. So yeah, anything to add to that at all, Willow Harris?
Karis, do you want to say anything before I do? Oh, yeah. Okay. Um, well, I was looking at it from a sort of legalistic point of view. I mean, we were talking before we uh, started the live stream to about having a sort of checklist or a tree for what a council should do. And looking at this legally, I was sort of mentally writing a pre-action letter to the council on a judicial review and think where they've gone, where they're acting unlawfully. Because presumably here, it's unlawful that they've failed to process a homelessness application. And they've clearly got reason to believe. I mean, she's made a homelessness application, hasn't she? I mean, she's been in there. And so the question is she homeless? And the answer would be yes, because she's in unsuitable accommodation and also a Section 21 notice has been served. Presumably, let's assume it's valid, and also let's assume the landlord is intending to carry it and go forward with it. So that would be at least two reasons. Um, so then you could judicially review them and say, get an order requiring them to process the application and give her temporary accommodation under Section 188. The only problems with that might be that the council might say, um, they might lean on St Mungo's and say, actually, we're not going to issue proceedings. So that would be the second of those gone. And the other one would be they might try and say, well, we think a hostel's okay really for now, and it's owned by the council, so it can't technically be bed and breakfast accommodation, even if it's got shared facilities. So you could be on for a fight, but I suspect they might back down. And but Mike, what do you think St Mungo's should be doing apart from, do you think that your criticism of them is for not issuing possession proceedings?
No, so okay, so again, this probably would be good to clarify. So my understanding of St Mungo's is that they are like a YMCA. They're a supported housing provider, which is not. So when we're talking about hostels here, I'm reading that to be not like the kind of hostel we talk about when we talk about temporary accommodation. So this is something else. This is like, this is I would read this as being, this is just normal supported accommodation where it's very typical that you are not able to have kids in there at all. So that would be how I'd be reading it. I guess a couple of questions. Again, we're talking about the law here, so it's all pernickety. It talks about Section 21 there. But it also talks about a notice to quit. If it's what I think it is, it will be a notice to quit, not a Section 21. But that would be kind of something this would be good to go back and check. Okay, what, is this a tenancy? I don't think it's going to be a tenancy. I think it's going to be a license. That would be my guess. But again, I don't know. Some Mungos might do stuff I'm not aware of. They might manage temporary accommodation for a council or whatever. But yeah, when I read that, the fact is, I mean, we got one in Bedford, for example, which is council owned, but it's managed by another charity, and that's all licenses basically. So they can evict them pretty short notice, and yeah, in that environment, they would not be allowed to have kids. So not that you want to bring children's services in particularly because they're probably going to mess things up somehow. But in one sense, it would be something where the children's services would it's a safeguarding issue. If I'm reading that correctly, you can't have a mum and baby in an environment like generally speaking, I think we're talking about somewhere which is a lot of people, predominantly men. Probably quite a lot of ASB and kind of drug and alcohol issues. If I'm being prejudiced in that environment, that's not somewhere to be having a baby, basically. So yeah. So if I think I've got the right end of the stick there, I think it's probably legally very simple. They have nowhere whether it's reasonable to continue to occupy indefinitely because of this rule that you can't have kids. That means she's homeless, she's got a kid, or she's pregnant. I'm not quite sure if the baby's been born, right? Yeah, 2 months old. Yeah, automatic priority needs, indefinite leave to remain. We're going, yeah, assuming that it's pretty clear cut, that she can be eligible. So yeah, yeah, I think that'd be my answer. I think if I've read it right, it's just to literally today put a homeless application in, or tomorrow, whenever you can meet up with her and kind of get the consent and stuff, and then wait a day and just immediately start complaining. I mean, I think this is the sort of situation which the LGSCO would actually step into probably more quickly, because they have this ability to step in when there's like urgency. And if literally the council continues to refuse to take an application and continues to refuse to house them, I think that might be the sort of situation where where they're getting. I think it's yeah. So just the person saying about there's not it's not entirely clear about Section 21. I think it's because they're kind of they're legal terms, but we use them kind of colloquially and kind of not very precisely quite a lot of the time. So yeah, I mean it'd be quite simple to find out. One way would be to speak to some mungos and say, are these tenancies? And the other thing would be to ask the person, have you got a tenancy? What have you signed? Let's have a look at the notice to quit and so on. So yeah, I mean, but by all means, like if that person wants to ask a question, I mean, if this, I can't remember if this person's got my email address, feel free to email me or put a question onto the comment on the channel, and I'll basically get back as soon as I can, because that seems to be like the sort of situation which can get sorted out very quickly. The council just needs to step in on, basically, if I've read it right. So yeah. Um, so right, next question. This is a multi-parter as well. So, can you please also explain if a person is owed a main housing from the council, but has rent arrears, has stopped paying because of abusive behaviour from one of the tenants, landlord not taking action, can it prevent a person from getting social housing, or can a person explain it, including crime reference number, from the police and be found not intentionally homeless, so a person will be still allowed social housing rather than private rented? Okay, so right. First thing first is the default advice that you're going to get if you ever ask an advisor, and the information we're going to give you here, is that no matter what is going on in the property, don't withhold rent ever. So I would say to someone in this situation, start paying your rent now, whatever it is. Just start it all up, get it kind of underway. Because even if the council owes you the main duty, it depends on the council basically. Because certainly for a council that owns none of its own stock, as in its housing stock, they are completely at the whims of the local housing associations. So in Bedford, in this situation, the council might have a duty to house that person, might owe them the main duty, but then none of the local housing providers would actually take the person with more with rent arrears basically. So yeah, what it might do is limit the person to private rented. Um, what it probably will do is limit the person to private rented anyway. In terms of it being intentional homelessness, uh, it's not with like so withholding your rent is definitely something which can lead to an intentional decision, but you'd have to get evicted for it first. So yeah, I think if the person was to immediately start paying them what's owed, make some kind of payment plan. I mean, I think if you're going to withhold rent as well, you need to withhold it and not spend it on other stuff. So you need to have it up your sleeve. I mean, that's not that I'm saying you should do it anyway, but if you are going to do it, if you spend it on other things, that looks bad when it comes back to, actually you're kind of been judged here by the council for other things. There's quite a few moving parts, I'd say, I guess, in my answer to here. So or in ordinary circumstances, withholding your rent absolutely can lead to an intentional decision, but it's not automatic because there are other moving parts. Because I think this, as I said, I think this is a question about unsuitability of accommodation. And so if the accommodation is actually unsuitable, is unreasonable to continue to occupy, then it doesn't matter what you do. You could go and punch your landlord in the face if you wanted to, and that doesn't make you intentionally homeless. It does probably put you in jail for assault, but that's another issue from a housing point of view. It's not, you can't be found intentionally homeless from accommodation that's not reasonable to continue to occupy. But that, yeah, as I say, but it's high risk strategy, and I don't know what you gain from not paying the rent. So yeah, I think I've answered the main points there. But again, it kind of there's a few things it hinges on which we're not sure of. Will, do you want to add anything to this one at all?
No, I mean, I definitely agree with everything you said there, and especially about do not withhold rent. I mean, I think the only thing you might gain from that is a sort of sense of empowerment that you're sort of messing the landlord around, and getting some sort of satisfaction from that, in response to them not helping you with the abusive behavior. But yeah, I mean, the intentional homelessness would be a big worry. But if you could show that you were genuinely experiencing abuse from other tenants, I guess you could say it wasn't reasonable for you to continue to occupy. But you'd be on thin ice because if the other tenants moved out, um, you'd be in a mess because they'd say, well, that was a problem, but there's nothing to stop you living there now. So yeah, it's and as you say, there's a lot of councils with allocations policies that won't give you somewhere if you've got rent arrears. So it's lose-lose, I think, if you withhold the rent.
Yeah, I mean, there's quite a few in the session I'm going to do the webinar in a couple of weeks on intentional homelessness. I will literally be talking about cases specifically where this has happened, and yeah, it just doesn't go well for people basically. So yeah, I think this person needs to immediately just get back on it, pay rent, pay any outstanding arrears. If they can do that quickly enough, then yeah, then basically they can get unbarred effectively from social housing. Um, uh, Again, the only way you can know for sure is to have a look at each individual housing provider's policy, because different housing registered social landlords do have different like thresholds of arrears. It's pretty common though. I say that I have seen housing associations basically when they can see a long-term commitment to pay off rent arrears, they will accept them. So let's say someone owes them 2 grand, or so owes someone else 2 grand, quite frankly, and the person is paying off regularly small amounts over the period of 6 months or so, then that can be seen as a commitment to pay it off, and that will be kind of seen as, kind of enough to kind of get around the exclusion. But yeah, not recommended course of action by any means. So yeah, um, last orders on questions, guys, because that's we've done them all as far as I can see. Just to reiterate, questions about benefits and housing benefit and DWP, not something we have expertise at all on this live stream. So just not in a position to answer those really, unfortunately. I mean, there are some Facebook groups which are kind of geared up for benefits. Uh, Not that I can remember the names of any. I'm a member on a few of them. But yeah, but so it might be you can kind of ask a question there. Again, if you're using Facebook groups, just anonymize, yeah, kind of ask the question anonymously. Don't put your personal data on there. You never know who's watching, basically. So yeah, as an aside, it always makes me laugh the number of people who oppose digital ID and yet they're like flinging their data everywhere, or here, there, and everywhere anyway. But yeah, that's another thing. So yeah, I think that's it, guys. I can't see any more questions. So we will be back here next Thursday. Hopefully, this has been useful. Sign up to the intentional homeless decision webinar on the 14th. The spaces are filling up quite quickly. So if you go on Eventbrite and you search for homelessness best practice, you'll see the events that are coming up. It's a free event. So yeah, it'd just be a good time to kind of go looking at intentional homelessness in much more detail and kind of take questions and kind of answer them as we go. But yeah, other than that, guys, take it easy
Right.
and hopefully this has been useful.